All right, let's dive right into this Supreme Court case, Return Mail, Inc. versus United States Postal Service. It's a pretty significant one. It really gets at the heart of something fundamental. Can the U.S. government, or agencies that are part of it, like the Postal Service in this instance, actually be considered a person, legally speaking?
Yeah, you hit the nail on the head there. It's a super interesting question.
Especially when they're trying to kick off these specific patent review processes, right?
Exactly. Those post-issuance proceedings at the PTAB, the Patent Trial and Appeal Board.
We're talking about inter partes review, or IPR for short. And then there's covered business method review, which everyone just calls CBM review.
Yep, those are the two big ones at play here. And the Supreme Court's decision was pretty clear-cut. Generally speaking, the government can't just jump into these patent challenges by claiming they're a person.
So right off the bat, listeners, that's the outcome. But obviously, there's a whole lot of legal reasoning that led to that decision.
Oh, absolutely. And to really grasp it, we need to unpack the arguments from both sides. Starting with Return Mail, the company that actually held the patent in question. Their main argument was all about how we interpret legal language, the very words used in laws.
Okay, so break that down for us. Where did Return Mail start?
Their foundation was this long-standing legal principle. It's almost like a default setting, you could say. The idea is when you see the word person in a law, it's generally assumed to be talking about, regular folks, individuals, companies, private entities, not the government itself.
Like a built-in assumption.
Right. Unless Congress, the folks who write these laws, specifically state otherwise. And Return Mail pointed to this thing called the Dictionary Act, which kind of backs up this whole idea.
Makes sense. So it's not like they just pulled this out of thin air. There's legal backing for that interpretation.
Exactly. And they emphasized how the America Invents Act, we'll call it the AIA, from now on, the very law that created these IPR and CBM review processes. Well, it doesn't explicitly say that the government gets lumped into the definition of person for starting these challenges.
So their argument was pretty straightforward. Congress didn't write it in, therefore the government can't do it.
Precisely. But they didn't stop there. They went a bit deeper, looking at the overall structure of this whole patent review system that Congress set up.
Like the checks and balances.
Yeah.
They argued Congress built those in.
You got it. One of those was this concept called estoppel. Now, I know that might sound like legal jargon.
It kind of does, yeah. Maybe we can explain that simply for our listeners who aren't lawyers.
Sure. Think of it like this. Let's say you go to court, you're arguing a specific point, and you lose. Estoppel basically means you can't just bring that exact same argument up again in another similar setting. You're stopped, prevented from rehashing it.
Okay, so you only get one shot to make that argument.
Pretty much. And Return Mail pointed out that the AIA actually has an estoppel provision specifically related to these IPR and CBM reviews. It basically says that if a patent holder goes through one of these processes and loses, they're prevented from having to defend that same patent all over again in a regular district court or at the International Trade Commission.
Wow, the ITC. Yeah, we've covered them before. So it's like once the PTAB makes a decision, it's kind of final in those other venues.
Exactly. It brings some finality, prevents things from getting dragged out endlessly.
So how did Return Mail tie this whole estoppel thing back to their argument about the government not being a person who can start these reviews?
Well, here's the clever part. They focused on what that AIA estoppel provision specifically mentions. It talks about how the outcome of an IPR or CBM review affects cases in district courts and the ITC. But there's a very important court it doesn't mention. The Court of Federal Claims.
And that's significant because
that's the main court where the government typically handles patent infringement issues. So Return Mail's argument was, hey, if Congress wanted the government to be a person who could trigger these AIA reviews, wouldn't they have included the Court of Federal Claims in that estoppel provision?
it's like they left out a key piece of the puzzle if they truly intended the government to be part of this whole process.
That was their point, exactly. It suggests Congress had a very specific set of players in mind when they designed the system.
I remember Justice Ginsburg asking Return Mail's lawyer whether their entire argument hinged on this estoppel provision, though, right? Like, was that the be-all and end-all of their case?
Yeah, Justice Ginsburg really wanted to get to the heart of that. And, the counsel for Return Mail was adamant that their core argument based on the Dictionary Act and this general presumption against including the government, unless stated otherwise, that would stand on its own. The estoppel point was more like extra support, reinforcing their interpretation of what Congress meant.
Okay, so the estoppel part was like a bonus argument, but their primary point still stood even without it.
Exactly.
Which makes sense. Now, obviously, the government has a huge interest in making sure that there aren't any patents out there that shouldn't have been granted, right? Like bad patents, as they're sometimes called. How did return mail address that?
They didn't shy away from that at all. They acknowledged the government's legitimate interest in keeping the patent system, well, legitimate.
Sure, they want to make sure the system's working as intended.
Right. But return mail's point was, even if you exclude the government from directly initiating IPR and CBM reviews, it's not like they're left powerless to deal with potentially invalid patents. They can still do something about it.
What's that?
They highlighted the fact that the director of the Patent and Trademark Office, that's PTO, the director, has this power to start what's called an ex parte reexamination of a patent, even after it's been granted. And they can do this sua sponte, which basically means on their own initiative without anyone requesting it.
So it's like a backdoor way for the government to get a patent reviewed.
In a sense, yes. And this is where Justice Sotomayor really dug in during the oral arguments.
I remember that. She had some really sharp questions.
She did. She basically asked, how can the Postal Service, or any government agency for that matter, even trigger this ex parte reexamination process if they're not considered a person under return mail's interpretation? It seemed like a bit of a contradiction.
Right, because if they're not a person, how can they take any action within the system?
Precisely. And return mail's response to that was very specific. They pointed out that the ex parte reexamination process can actually be started in two ways. One is through a request from a person, which we already established the government might not be, according to their argument. But the other way is through this sua sponte initiation by the PTO director, like we just talked about.
So they were basically saying Congress gave the government this other avenue through the director to deal with these potentially problematic patents.
Exactly. And they even pointed to specific sections within the Patent Act that outline these two distinct paths for starting an ex parte reexamination, suggesting it was a deliberate choice by Congress to give the government this alternative route.
It wasn't just some oversight or accident.
Not at all. It seemed very intentional. But, amidst all this back and forth about person and the Dictionary Act, Chief Justice Roberts voiced some skepticism.
Yeah, I was going to bring that up. He seemed to question whether blindly relying on the Dictionary Act as some kind of universal truth was a bit too simplistic.
He did. He wondered if it wasn't a bit of a legal fiction, to use his words, because even return mail admitted that sometimes person does include the government, depending on the context of the law.
He was essentially saying, if it's really this ironclad rule, why doesn't Congress make it crystal clear every single time they want to deviate from it?
Right. Instead of leaving it up to the courts to figure out the nuances of each individual statute. And return mail's response to that was interesting. They argued it wasn't about leaving everything up to guesswork. Their point was that the Dictionary Act provides a baseline, a starting assumption. And then it's Congress's job to signal clearly through the language and structure of a particular law when they want person to include the government.
So it's like a default setting that can be overridden, but Congress needs to be explicit about doing so.
But that's a good way to put it. They need to provide those contextual clues. And return mail even brought up specific examples from within the Patent Act itself to make their case.
Like what?
They pointed to sections dealing with things like how to get information from someone who's applied for a patent, what remedies are available if someone's falsely claiming their product is patented, and the process for the PTO director to refer potential fraud cases to the Attorney General.
Okay, pretty specific stuff.
Very specific. And in all of those instances, the way person is used really suggests that it doesn't automatically encompass the government. It's clearly talking about private entities.
So it seemed like they were saying, look, Congress knows how to use person differently when they need to.
Exactly. And they also brought up the fact that the government can own patents, right? And they can defend themselves in court if someone accuses them of patent infringement. They use that to bolster their argument, too.
Right. So walk us through that part.
They referenced Section 207 of the Patent Act, which very clearly states that federal agencies can own patents. And then there's Section 1498, which outlines how the government can fight back if they're sued for supposedly infringing on someone's patent.
It's like Congress clearly had the government in mind when they wrote those parts of the law.
Absolutely. And return mail argued that those sections are prime examples of when Congress intentionally included the government within the scope of the Patent Act, and they used specific language to do so. They contrasted that with the AIA review provisions, where that same clear affirmative language is missing.
Okay, so that lays out return mail's side pretty thoroughly. Let's switch gears now and look at what the government argued. Their representative was the Deputy Solicitor General, right?
Yeah.
What was the main thrust of their argument?
Yeah, the Deputy Solicitor General presented the government's case, and their central argument was that the term person in those specific sections of the AIA that deal with IPR and CBM review should actually be interpreted broadly enough to include federal government entities.
They weren't disputing the Dictionary Act definition. They were just saying it should be applied more expansively in this situation.
That's right. Their reasoning was basically that these review mechanisms, these IPR and CBM processes, they were created for everyone's benefit. They provide a way to challenge patents that might not be valid, and the government argued that the reasons for having those challenges exist, whether it's a private company or a government agency that's requesting the review. The logic behind it applies equally.
So in their view, excluding the government would kind of defeat the purpose of having these review mechanisms in the first place.
Exactly. And they even brought up some previous Supreme Court cases to support this idea of interpreting person more broadly.
Of what cases?
They cited cases like Georgia v. Evans and Pfizer, where the court had previously decided to include entities that wouldn't normally fall under the typical definition of person, especially in situations where excluding them would lead to a result that just didn't make sense in light of the law's purpose.
So they were arguing that excluding the government in the return mail case would create a similar illogical outcome.
Exactly. They were saying, look, the court has done this before, there's precedent for it. And remember that Section 1498 we talked about, the one that allows people to sue the government for patent infringement?
Yep, I remember that one.
Well, the government actually used that same section to support their argument, but in a different way than return mail did.
How so?
They argued that the very existence of Section 1498 proves that the government is already considered a participant in the patent system. It's right there in the law. So allowing them to use IPR and CBM review as well would just be a natural extension of that participation.
They were basically saying, hey, we're already players in this game. We should be able to use all the tools available.
Yeah, that was the gist of it.
Yeah.
And they argued that letting the government use these tools would actually help make the whole patent system run more efficiently.
Because if they can challenge patents that are potentially invalid, it clutters the way for better innovation, right?
That was their reasoning. But some of the justices raised some pretty significant concerns about the whole idea of the government being both a challenger in these patent reviews and also part of the executive branch that oversees the PTT.
Yeah, it does seem a bit odd, like they'd be arguing before their own agency.
Right. There's a potential for conflict of interest there. And the justices also questioned whether the government would truly be bound by the PTAB's decisions if they later ended up in a patent infringement lawsuit in the Court of Federal Claims. Like, would they be able to just ignore what the PTAB decided and argue the same points all over again?
So it's about consistency and fairness within the system.
Exactly. And the government's response to that was that, yes, they could be estopped, meaning prevented from relitigating issues that were already decided by the PTT. But there was a caveat.
What was that?
They acknowledged that the specific estoppel rules written into the AIA don't actually apply to the Court of Federal Claims. So they argued that a more general principle called common law estoppel would probably kick in instead.
And what's the difference between those two types of estoppel?
Well, the AIA's statutory estoppel, the one specifically written into that law, can sometimes prevent you from making arguments that you could have brought up but didn't. It's broader. Whereas common law estoppel usually only applies to arguments that were actually presented and decided on.
So it's a more narrow type of estoppel.
Right. And Justice Sotomayor really zeroed in on this distinction. She questioned whether it was reasonable to assume that Congress had really thought through all these potential estoppel complexities in the Court of Federal Claims if their intention was to let the government initiate PTAB reviews in the first place.
It's like if you're going to make such a big change, you'd think you'd iron out all the wrinkles beforehand.
That was her point. And then the government circled back to Section 207, the one about federal agencies being able to get patents.
Right. They use that as another argument for why they should be considered a person when it comes to challenging patents, too.
Yep. They argued that by specifically allowing federal agencies to hold patents, Congress was clearly indicating that they saw the government as an active player in the patent system. So it would stand to reason that they should have access to the same tools as everyone else to make sure that system is functioning properly.
It's about leveling the playing field, essentially.
Exactly. And they even suggested that the Postal Service's decision to use CBM review in this particular case against return mail was a strategic one.
Oh, interesting. What was their thinking there?
The Deputy Solicitor General pointed out that by using CBM review, the Postal Service was trying to avoid having the whole issue of whether the PTO had correctly granted the patent in the first place land in the Court of Federal Claims. They were basically trying to keep the dispute within the executive branch through the PTAB process.
Maybe they felt like that was a more efficient way to handle it.
It seems like it.
Heck.
But the justices pushed back on that, asking why Congress would let the government initiate a less formal process like ex parte reexamination, but not the more robust adversarial IPR or CBM reviews.
Yeah, it does seem like a bit of an inconsistency.
It does. And the government's response was basically that the different estoppel rules that apply to each process and the fact that ex parte reexamination is more one-sided, while IPR and CBM are more like mini trials, well, those differences could explain Congress's thinking.
So they were saying maybe Congress was more comfortable with the government initiating the less confrontational process.
Exactly. But the justices also brought up concerns about transparency. They worried that if government agencies could influence the PTO outside the formal procedures for ex parte reexamination, it could lead to some shady dealings behind closed doors.
Right. It could undermine the fairness of the system if there's a perception of undue influence.
Absolutely. And then the government brought up an interesting point. Patents owned by the federal government are already subject to IPR and CBM challenges from private companies.
So anyone can challenge the government's patents.
It seems so. And they used this to argue that the AIA was intended to create a level playing field. If private companies can challenge the government's patents, why shouldn't the government have the same ability to challenge patents held by private companies?
Makes sense. It's about reciprocity.
Right. And finally, the government tried to downplay the potential problems that might arise if they were barred from initiating IPR or CBM reviews. They pointed out that federal agencies hadn't actually submitted that many requests for these reviews since the AIA was enacted, so the practical impact of a ruling against them might not be that huge.
So they were trying to minimize the potential fallout.
Exactly. But regardless of the practical implications, the court ultimately sided with return mail, emphasizing the importance of clear congressional intent when it comes to defining who has the power to initiate these patent review processes.
All right, so now it's time for our favorite segment, the 10th chair. We put on our imaginary justice robes and weigh in on the case.
It's tricky, right? On the one hand, you have this long-standing legal principle enshrined in the Dictionary Act, this idea that person usually doesn't include the government unless explicitly stated.
And the court has a duty to uphold that principle, to ensure clarity and consistency in how laws are interpreted.
Absolutely. But then there's the practical reality that government agencies are increasingly involved in patenting and technology development. Shouldn't they have access to the same tools as everyone else to challenge patents that might be questionable?
It's a valid point. The goal of the patent system is to promote innovation, right? And if a patent is actually invalid, it could be hindering that progress.
Exactly. Especially if the government is being forced to work around a patent that shouldn't have been granted in the first place. That could be costing taxpayers money.
So there's a strong argument to be made that excluding the government from these review processes could actually be detrimental to the overall goal of fostering innovation. It seems like the court really grappled with these competing interests, these legal principles versus practical considerations. And ultimately, they came down on the side of a stricter interpretation of the law.
They prioritize that clear textual interpretation and also the separation of powers. They seem to be saying, look, if Congress wants to give the government this power, they need to say so explicitly. It's not the court's role to rewrite the law.
And that's a fair point. It puts the ball back in Congress's court, so to speak. If they want to change the rules of the game, they need to do it through legislation.
It's a reminder that even seemingly small words like person can have enormous implications in the legal world. And clear drafting is essential to avoid confusion and potential conflicts down the line.
This case is a great example of how legal interpretation can have a ripple effect throughout the entire patent system.
And it highlights the constant tension between upholding legal principles and adapting to the evolving landscape of innovation.
So listeners, we've laid out the arguments, the court's decision, and even offered our own 10th chair perspective. Now we want to hear from you. What are your thoughts on this outcome? How do you think this will impact future patent disputes involving the government? Join the conversation and let us know.